As a building code administrator, I have had the opportunity to work with some fantastic code enforcement staff. This training on the legal side of the legalism and management of your exam and your training is very valuable for you, and I hope it's very helpful for you. So let's get started. We ask that you like and subscribe these videos. Through enforcement of code, building officials serve as law enforcement officers, requiring compliance with code through procedures defined by legal due process. Such a statement does not imply that they are policemen or have the power of arrest, but indicates that they are involved and responsible for the enforcement of certain laws. To perform their duties and function properly, they are endowed with considerable authority. The mechanics of carrying out or invoking either of the components are governed by applicable laws, including the United States Constitution, which provides the building official with a broad spectrum of legal rights, restrictions, mandates, and prohibitions. Omitting or ignoring any required legal step is not permitted. It dilutes the intent and effectiveness of the law and raises serious questions about the integrity or competence of the building code department, who is responsible and may be held accountable. Code officials who intentionally or recklessly fail to perform a required duty and thereby cause injury may be prosecuted in those states which have criminal law provisions for such actions. Intentional, malicious, and grossly negligent conduct against the code are not defensible under sovereign immunity. 4 standard theories of liability. Number 1, negligence. Failed a duty, no intent was needed. Intentional tort, knowingly violated a duty. Civil rights violation, violated a protected right. Criminal violation, intentional or a reckless act. The 2 primary governmental defense actions include the public duty doctrine and sovereign immunity. According to the court, the public duty doctrine is a focusing tool used to determine whether the state owed a specific duty to a particular individual, the breach of which is actionable, or merely a duty to the nebulous public, the breach of which is not actionable. In its broadest terms, sovereign immunity stipulates that the state may not be held liable for any wrongdoing which it or its agents have committed. This ancient doctrine originated in England, where it was widely accepted that the king could do no wrong. Immunity can further be defined as absolute or qualified. Absolute is a policy of protecting public officials from tort liability. A high-level officer cannot be held liable for the discretionary acts or omissions, and it only applies to actions that are functions of the job. Qualified immunity is more likely to be used for building officials and inspectors. The qualified immunity given to lower administration officers is much more commonly applied by the courts. The rationale behind a qualified privilege is that it is sufficient to protect the honest officer, and the burden and inconvenience of any injury regarding motives far outweighs the possible evils of deliberate misconduct. For example, in Rotkamp v. Young, a zoning official was sued for his failure to issue a building permit for a restaurant. The official found that the description of the activity given to him on the application did not meet the applicable provisions of the zoning ordinance. On this point, the zoning official was overruled via a declaratory judgment, but the court found no tort liability. Respondent superior holds the principal responsible for the wrongful acts of the agent. Therefore, in theory, your supervisor and employer can be held responsible for your failures. However, most states extend sovereign immunity to the government employer and supervisors for negligence performed by acts of the employee caused by either accident or mistake. Liability of the employee, supervisor, and agency depend on jurisdictional laws. A ministerial act is a duty that does not involve the exercise of judgment. A building inspector working under the authority of a building official is an example of a ministerial position. That is, the inspector's work is delegated and performed under the authority, policies, and procedures of the building official. A ministerial act is performed because the law requires it. The act does not involve discretion. The work of the building inspector, as well as the permit tech and other office staff, is considered ministerial acts. When a law, policy, or directive clearly establishes that an act must be performed, the relevant officials are not free to exercise their own judgment in determining whether to perform the act or not. Terms often used are shall, must, and will. A discretionary act is an act of choice. It is a power or right bestowed upon an officer acting officially under certain circumstances, according to the dictates of his or her own judgment and conscience, uncontrolled by judgment or conscience of others. The International Building Code uses words that authorize the building official to carry out discretionary acts. IBC Section 104.10, for example, states that the building official shall have authority to grant modifications in individual cases under certain circumstances. This is an example of a building official being authorized to use his or her own judgment. The most common debate concerning ministerial and discretionary acts centers on inspections. Some are discretionary, while others are ministerial. Two large sources of litigation: failure to inspect where required by law, and performing an inspection in violation of the law. A breach of duty is an element in a negligence cause of action. It is the neglect or failure to fulfill in a just and proper manner the duties of an office. The duty owed by the building official must in some manner have been violated. If the duty is satisfied, no liability will ensue. There are essentially two ways in which a duty can be breached: by action or by inaction. For example, failing to make a required inspection would be considered inaction, which breaches a care of duty. Most building code problems result from inaction. An inaccurate inspection would be considered an active breach of duty. To use more legal terms, a breach of duty can result through misfeasance, nonfeasance, or malfeasance. Misfeasance is the improper performance of some act by a person. Malfeasance is the doing of an act that a person ought not do at all. Nonfeasance is the non-performance of some act by a person who is obligated or has the responsibility to perform. In a negligence case, duty may be defined as an obligation to a particular standard of conduct toward another. Breach of duty can be defined as the neglect or failure to fulfill in a just and proper manner the duties of an office. To prevail on a claim of negligence, a plaintiff must satisfy four elements. The defendant, possibly a building official, must have 1. Owed a duty to another to act according to a certain standard. 2. Failed to act in accord with that standard, and therefore 3. Breached that duty. 4. Thereby causing, in the eyes of the law, an injury or damage to the other. The plaintiff must prove each and every element of a negligence claim by a preponderance of the evidence. For example, if a building inspector has a legal duty to inspect every building in the manner that an ordinary, reasonable, and prudent building inspector would, and he or she has not done so, the first two elements of the legal theory have been satisfied. That inspector had a duty and breached it. On the facts alone, a non-attorney would likely believe that this building inspector was indeed negligent. If the inspector's failure to inspect properly, however, did not cause the party to whom the duty was owed a legally recognized injury, there will be no legal liability. In most cases involving building codes, the question becomes, to whom is the duty to act owed? If the plaintiff is not owed any duty of care by the defendant, the first element of the cause of action is missing, and the case is subject to dismissal. To protect the building official, most states have adopted the public duty doctrine. This doctrine provides that a plaintiff who is alleging inadequate performance of a governmental activity has the burden to show that the municipality owed a duty to the plaintiff and not just to the general public when performing the activity that gave rise to the complaint. If the activity is designed for the general public, the cause of action fails for lack of legal duty to the plaintiff. Under the public duty doctrine, the courts would look to the purpose of the building code to determine to whom the building inspector owes a specific duty. Therefore, because the purpose of the building code is to ensure the safety and protection of the public at large, a plaintiff's cause of action against the building inspector will probably fail. If a building official approves a building permit for a building with faulty wiring and the building burns down, all those people whose family members were killed in the fire do not have a claim against the inspector. The courts will find that the duty was owed not only to the inhabitants of the building, but rather to every member of the public. Because the duty was not limited to the people who lived in the building, the duty element of negligence cannot be satisfied. There are, however, two exceptions to this doctrine. The first occurs when a plaintiff can clearly establish that the building official owes a specific duty to a class of people, and the plaintiff is a member of that class. The second exception occurs when the plaintiff can show that there exists a special relationship between the building official and the plaintiff, which would cause the plaintiff to rely on the building official more than he would the general public. These exceptions are almost impossible to satisfy. There are some states that do not adhere to the public duty doctrine. It is very important to consult with the municipal attorney to determine whether or not the state you are living in has the public duty exemption. Because case law is ever changing, this should be checked every few years to make sure that the law has not changed. Let's look at two cases involving the public duty doctrine. In Emringley versus Town of Richmond, the facts of the case were these. The plaintiffs sued the Town of Richmond and the code enforcement officer for failure to properly inspect construction of their house. Problems began to occur with the construction after the issuance of the building permit to modernize their home. It's interesting to note that a certificate of occupancy was prepared but never delivered to the plaintiffs. The courts held that a municipality is not liable for the negligent acts of its employees engaged in a discretionary municipal function. Without evidence of a special relationship between the town and the landowner, no recovery was allowed. In our second case, Fike versus Morgan, the facts of the case are these. Plaintiffs sued the city for negligence for breaching its duty to properly inspect and approve the construction of the foundation of their residence. The city issued a building permit to the contractor owner to build an addition onto the home. The home was inspected over 40 times for compliance with the building code, and a certificate of occupancy was issued. The property was subsequently sold to the plaintiffs. In the hearing, the experts testified that there were numerous violations of the building code. The city argued that the public duty doctrine shielded it from liability because it did not have a special duty to the plaintiffs, just to the public at large. In the court finding, they held that they would decline the public duty doctrine argument. The court found that the city was liable for damages caused by an employee's negligence, and under the circumstances, the employee would be personally liable to a claimant in accordance with the laws of that state. It did find that the legislature could choose to limit the liability for local government in this area by passing necessary statutes. The word tortious is used to denote the fact that conduct, whether by act or omission of act, is of such a character as to subject the actor to liability under the principles of the law of torts. To establish tortious act, plaintiff must prove not only existence of actionable wrong, but also that damages resulted therefrom. Intentional torts, as the name implies, involves conduct that the actor intended to occur. Negligence, on the other hand, involves conduct that was not intended to cause harm, but nonetheless did so, and also breached some duty of care imposed by law. Legal due process is another constitutional right a building official must be careful not to violate. It involves both procedural and substantive due process. The term procedural due process means that parties whose rights are to be affected are entitled to be heard and therefore must be notified. As an example, if a builder has his or her occupancy permit revoked, the builder must be heard prior to the time of the revocation. In some cases, however, the court will waive the procedural due process requirements. For example, if immediate revocation is absolutely crucial to the health and safety of the inhabitants of the building, the court might waive the owner's procedural due process requirement. A building official, however, should never assume that the court will do this. Rather, the building department should, if possible, always give the owner an opportunity to be heard. The term substantive due process means that any and all legislation enacted by government must bear some rational relationship to a legitimate governmental function. In other words, the law must make sense. Courts adjudicate constitutional issues when the parties raise claims of constitutional rights, usually under the 5th and 14th Amendments, as a defense to the actual or threatened enforcement of law against them. If they determine that a law deprives people of their rights under the Constitution, legislators will be on the alert that in the future courts will find this type of law to be unconstitutional. Case study, procedural due process, Massey versus Charlotte County. Facts. The Charlotte County Code Enforcement Board imposed a lien on property owned by the plaintiffs for failing to obtain permits before constructing improvements on their land. The plaintiffs received notice of and participated in the hearing that found them in violation. Subsequently, a building inspection supervisor submitted an affidavit of non-compliance for their failure to comply with the permit requirements after the first hearing. He asked for a fine of $100 per day. The board issued such an order without notice to the plaintiffs. Held. The court found that the plaintiffs were not afforded procedural due process because there was no process established whereby the plaintiffs could contest the imposition of the daily fine. They had received due process during the first hearing, but not at the subsequent order by the board. Until the early 1960s, federal, state, and local governments were almost completely unaffected by civil rights legislation. In 1961 and in the years following, the Supreme Court has begun to interpret hereunto untapped legislation that proved cause of action for people who suffered civil rights violations at the hands of the government. As of yet, lawsuits brought under the Civil Rights Act have not posed too much difficulty for building officials. As is true with state lawsuits and state legal theories, building officials are difficult to reach. Liability against building officials is difficult to establish in a federal lawsuit. Section 1983 is a cause of action under which a state or local government can be held liable for money damages and declaratory relief for violating the Constitution or laws of the United States while acting under the color of state law. Some commentators have declared that no statute is more important in contemporary America than Section 1983. Nevertheless, before 1961, the Civil Rights Act of 1871 was rarely invoked. In the last 35 plus years, however, this statute has become the basis for almost all constitutional rulings arising from the actions of state and local governments and their officers. To review a few definitions in our program, Ministerial Act is working under the authority of a supervisor. A writ of mandamus is a court order where the court commands the municipality to perform one of the duties it is responsible for performing. A summary action is an action such as a stop work order. Actionable means that for which an action will lie, furnishing legal grounds for an action. To continue with definitions, estoppel. Estoppel is a legal principle that prevents someone from arguing something or asserting a right that contradicts what they previously said or agreed to by law. It is meant to prevent people from being unjustly wronged by the inconsistencies of another person's words or actions. Estoppel can be understood by considering examples such as the following. A city entered into a contract with another party. The contract stated that it had been reviewed by the city's council and that the contract was proper. Estoppel applied to stop the city from claiming the contract was invalid. The professional staff at the Building Code Administration Office must understand the principles of constitutional law as they affect the daily administration and enforcement of building codes before resorting to forceful measures. Always seek the advice of the municipal attorney before forceful or legal action is taken. Whenever the building code requires notice to a party, notice must be given by the building official before a charge can be brought. It is a condition precedent, and any charge filed without the proper notice is subject to a motion to dismiss. It also serves common sense. How can the citizen correct a violation that they do not know about or understand the needs for correcting? The notice must contain each element required by the code provision, usually the name of the responsible party, the location of the property, the nature of the violation, and a deadline for correction and notice of the defendant's right to appeal. The notice must be served in a manner that complies with the code, whether it is certified mail, personal service, or posting. Notice of violation is covered in the IBC and provides that the building official is authorized to serve a notice of violation or order on the person responsible for the erection, construction, alteration, extension, repair, moving, removal, demolition, or occupancy of a building or structure that is in violation of the provisions of the IBC or in violation of a permit or certificate issued under the code. The order must direct the discontinuance of the illegal act or condition and the abatement of the violation. The I-codes also provide building officials the authority to halt construction activity immediately if deemed necessary. Building officials have the authority to stop work until code violations or other hazards to the public safety have been resolved. If, during the inspection process, it is found that the work is not going according to the plan submitted, the building official may wish to take summary action to revoke the permit or to issue a stop work order. Issuing the stop work order is the recommended first procedure. A stop work order is immediate action taken to abate a violation without formal court proceedings. Stop work orders are authorized by the IBC. A stop work order shall be in writing. It shall be provided to the owner or the owner's agent. It shall cite the work that must immediately cease. The order shall state the reasons and the conditions under which the cited work will be permitted to resume. The order must provide further direction for due process. Before issuing the stop work order, it would be suggested that the building official and contractor or owner meet first. And remember, all communication may become part of a legal record in future proceedings. After other administrative relief options are exhausted, an injunction may be sought by the building official. The remedy is, in essence, an order of the court which requires that the defendant cease and desist from all conduct that amounts to a violation of the building code. In almost every jurisdiction in the United States today, injunctive relief is broken into three types: a temporary restraining order, a temporary or preliminary injunction, and a permanent injunction. A temporary restraining order is an order issued by the court without notice to the other party and without an opportunity for the party to be heard. A temporary injunction is a judicial order that is issued pending a full hearing by the court. And a permanent injunction is a judicial order that is issued after the court has heard all the evidence in the case. The factual circumstances and legal standards that must be met in order to receive a temporary restraining order or a temporary injunction should generally be known by the building official so that an educated decision can be made whether to seek either. Both the temporary restraining order and the temporary injunction are usually subject to 4 legal requirements. First, the building official seeking the injunction must show that there is a significant threat of irreparable harm to the public if the injunction is not granted. Second, the building official must show that the harm the public would suffer if the injunction is not granted is greater than the harm that the other party would suffer if the injunction is granted. Third, the building official must show probable cause that he or she will prevail on the legal merits of the controversy. And fourth, the building official must demonstrate that the issuance of the restraining order or injunction is in the public interest. A significant portion of time is spent by building code departments responding to complaints regarding parcels of property. Some general guidelines relating to handling those complaints may be useful. First of all, the person who receives the complaint should obtain as much information as possible: the name of the complainant, his or her address, phone number, the date that he or she viewed the alleged violation, and the nature of the alleged violation are all important. It is also important for the person who handles the complaint to realize that the job of the Codes Department is made easier when the citizenry of the jurisdiction cooperates. Once a violation has been found, some action must be taken to enforce the code. Ordinarily, if the structure has been completed, the summary procedures of the revocation of a permit or issue of a stop work order are not available. Once the construction has been completed, prosecution in the city courts becomes the final method of enforcement. In most jurisdictions, a civil or quasi-criminal complaint may be filed against the owner or occupant of the property. Normally, with a civil complaint, the notice of violation may be served either through the mail or physically delivered to the alleged offender. In some jurisdictions, an alleged offender is still required to be arrested under an arrest warrant. A typical complaint in most jurisdictions will contain 6 elements. The first being the name of the person or entity. The first decision that must be made when a complaint is prepared is who is the party to be charged. Answering this question correctly will prevent lawsuits for false arrest. Designating the charge. Every complaint must contain the section number and the name of the violation. Body of the charge. Every ticket must contain a description of the violation which is sufficient so that the defendant can defend against the charge and to make sure he or she is not charged twice for the same offense. Date and time of offense. Each complaint must contain an allegation regarding the date and time of the offense. For ordinance violations, the date must fall within the statute of limitations. Signature of the complaining witness. Each complaint must be signed by an individual, either an inspector or a witness. Finally, number 6, notary or affidavit. Depending on the jurisdiction, a complaint may need to be verified by the person signing it, that is, sworn to under oath that the information contained therein is true and correct. The building department, by virtue of its function as a regulatory agency, is subject to legal attack at any time. Refusal to issue a permit, revocation of a permit, imposition of requirements, failure to perform an act, refusal to allow occupancy, or any of a host of other reasons can bring legal action against the building department, the community, the building official, and the department staff. A review of case law relevant to the Department of Building Safety follows. Building officials are involved with the legal aspects of code administration in 2 main ways: administration and enforcement. Through administration of code, building officials serve as the thresholds to public safety in the built environment, operating the legal processes necessary for the permitted construction, use, and occupancy of buildings and structures. Through enforcement of code, building officials serve as law enforcement officers, requiring compliance with code through procedures defined by legal due process. When moving forward with any enforcement activity, code officers and inspectors should be sure to know the limits of your authority. Be in a place you have the right to be. Inspect for conditions that violate the code, and refer those conditions outside of your scope to those who have the authority. Conducting inspections and the Fourth Amendment. The Fourth Amendment of the U.S. Constitution prohibits unreasonable searches and seizures. This applies to a code official inspecting a private property, as that inspection constitutes a governmental search. A code inspection is a reasonable search if it is conducted in accordance with the legislative standards. The easiest way for a building official to conduct a lawful inspection is to obtain the consent of the proper person. The plain view doctrine, an exception to the Fourth Amendment's warrant requirements. If there is any legal concept or practice that is helpful to regulatory inspectors and officers, it is the plain view doctrine. Basically, under the plain view doctrine, if code officials are lawfully in a position from which to view an object, if it is visibly a violation of the locally adopted code or ordinance, they may issue official warnings, notices of violation, or citations regarding the violation without a warrant. General consent considerations. Consent must be given freely by someone with authority of suitable age and discretion. It may be limited and it may be withdrawn. It does not authorize general entry of other agencies lacking legal rights. It allows you to report what you find to all appropriate other authorities. Code provisions often require inspection. If possible, always seek entry by consent. Cooperative compliance is always preferable. A building official must understand that the building code can never authorize an unconstitutional inspection. In spite of the fact that virtually every housing and building code enacted across this country contains a provision permitting inspections to be carried out in the line of duty, these provisions do not allow the building official to inspect someone's property in a manner which contravenes the mandates of the Constitution. The first and most important case in this field established that principle. In Camara versus Municipal Court of the City and County of San Francisco, a city housing inspector came to the lessee's apartment complex to perform a routine inspection. Upon arrival, he was told by the owner of the complex that the lessee of the ground floor was using the rear of the leasehold as a personal residence. The inspector determined that the occupancy permit did not allow residential use of that floor and demanded that the lessee consent to an inspection. The lessee refused, claiming that the inspector did not have a search warrant. A few days later, the inspector returned to the apartment without a warrant and asked again to be permitted entry in order to inspect the ground floor. Again, entry was refused. A short time thereafter, Camara was criminally charged with refusing to permit a lawful inspection and was arrested. The trial court sided with the city against Camara by finding that the mandatory inspection provisions of the San Francisco City Code was not contrary to the Fourth Amendment. This decision was affirmed by a California appellate court. Camara once again appealed the decision to the Supreme Court, which agreed to hear the case. The court began its analysis by stating the fundamental premise that a search of a private property is unreasonable unless consented to or authorized by a search warrant. It then addressed each of the city's three arguments in favor of carving out an exception to that rule in the case of municipal health and safety codes. The final decision by the U.S. Supreme Court determined that if the occupant, it need not be the owner, of a residential structure does not consent to an inspection, a warrant must be obtained in order to legally gain entry into the premises. And an occupant who does not consent to an inspection cannot be prosecuted for a violation of a law requiring obedience to the order of the municipal official. In the Tennessee case of Jackson versus Davis, two co-owners sued, among other defendants, two building inspection officials for an alleged Fourth Amendment violation. Specifically, the tenants of the residential structure, fearing that our electrical wiring was faulty, asked for an inspection of the electrical system. After examining the premises, the inspectors found a defective wiring system that made the residence unsafe and dangerous to human life. After the tenants moved out, the inspectors had the electricity disconnected. The trial court found that the inspector's search of the property was not in violation of the Fourth Amendment. It reasoned that once the premises had been rented to the tenants, those tenants were the only people who had an expectation of privacy. This expectation lasts for the duration of the tenant's lease. During that time period, the tenants were the only parties who had a legitimate expectation of privacy in the property. By requesting the inspection of the electrical system, the tenants had given their consent and thereby waived their Fourth Amendment rights. In spite of this decision, the building official should still exercise caution when entering a building without a warrant. In the Jackson case, the court found that the tenants had an exclusive right of occupancy and use of the building. In some situations, however, a tenant may not have such rights to the entire building. The building code official should always question the occupant in a detailed fashion about his or her rights to the property. Even if it seems clear that the occupant has total control over the entire premises, it is always better to err on the side of caution. In Cranwell v. Metz, a Washington case, the court agreed with the Jackson decision and extended its holding to allow a tenant to consent to a search of the common areas of an apartment building, such as the laundry room, the hallways, and the entryway. Cranwell also stated that a tenant's consent to search both his or her private apartment and the common areas of the apartment structure will override any explicit written refusal of consent on the part of an owner. The U.S. Supreme Court held in Illinois v. Rodriguez that an officer may rely on a person who acts like he or she has authority to consent to the search, but in fact does not. In that case, the defendant's girlfriend consented to the search of their apartment, even though she had already moved out. The evidence seized was not suppressed because the officers believed that the girlfriend had the authority and it was reasonable. Key points concerning the Fourth Amendment is the plain view doctrine, the exceptions in emergency situations. We will see the case of Michigan versus Tyler in the next slide. Heavily regulated businesses. For certain types of businesses, inspections are allowed without a warrant. Frey versus Panza. Reasonable expectation of privacy. Always get consent when you can. When in doubt, get a warrant. In an emergency situation, a warrant may not be necessary as found by a court. These cases can involve fire, flood, severe weather, a situation in which there is no time to gain a warrant. These are considered exigent circumstances. But be mindful, the courts consider businesses and residences differently when the conditions of exigent circumstances apply. Emergency situations constitute another exception to the Fourth Amendment's general warrant requirements. Emergency situations were addressed by the United States Supreme Court in 1978 in the case of Michigan versus Tyler. In 1970, a furniture warehouse fire, later determined to be arson, was first investigated the night of the fire and then the next day. And then the investigators returned 30 days later. All inspections or investigations were conducted without a warrant. Tyler, the lessee of the property, was arrested and convicted of arson. The conviction was reversed by the highest court of the state of Michigan because of a lack of a search warrant, and the case was appealed to the state Supreme Court. The Supreme Court determined that the warrantless intrusion in this situation was unconstitutional. The emergency was over. The officials had ample time within which to obtain a search warrant, and failure to do so violated the Fourth Amendment. In Michigan versus Clifford, a private residence was damaged by fire while the owners were out of town. The blaze was extinguished and the firefighters and the police left the premises. 5 hours later, arson investigators arrived and found a work crew boarding up the house at the request of the homeowner. Without a warrant, the investigators entered the property and found evidence of arson. The owners were charged with arson. In their defense, they moved to suppress all evidence against them on the basis that it had been obtained illegally. The courts held the following. The evidence obtained by the arson investigators was gathered in violation of the Fourth Amendment and had to be suppressed. There is a strong expectation of privacy in property used as a residence. Hence, the owners in this case retained significant privacy interest in their home. Without consent or exigent circumstances, the investigators needed a search warrant because the search was unreasonable. The court decided that an administrative search warrant is sufficient if the purpose of the search is to search for the cause of the fire. However, if the purpose of the search is to obtain evidence of arson, a criminal search warrant is necessary. An emergency situation is considered an exigent circumstance, but the exigency ends upon elimination of the danger. Once the emergency dissipates, the warrantless entry is no longer justified. Heavily regulated businesses. For the building official, this may be the most important exception to the Fourth Amendment's general warrant requirements. The Supreme Court has frequently observed that in particular types of industries, inspections without warrants are constitutionally acceptable. In determining if a warrantless search of a business is allowed, the court will consider whether the business has a history of being closely regulated, whether there is a substantial interest by the state, whether the regulation serves a substantial interest, whether a warrantless search is necessary, and whether the statute has an adequate substitute for a search warrant regarding notice and the scope of the search. The Third Circuit Court has held that the construction industry is one such regulated business. In Fry v. Panza, Darrell Fry, a home builder, on March 1, 1977, was in possession of a number of properties upon which he was constructing homes. The building official, inspector, Mr. Panza, would come by the site and conduct random inspections without his request. Fry sued Panza and the jurisdiction, claiming a 1983 constitutional violation, charging that the defendant's warrantless and unconsented inspections of these incomplete structures had violated his Fourth Amendment rights. The district court entered an order on November 2, 1977, dismissing the complaint on the grounds that no case had been called to its attention in which a court had extended Fourth Amendment protection to uncompleted and unoccupied structures. The right of the code official to inspect on an open permit has a regulatory exception to the warrant requirement. Since there is an increased governmental interest in public safety during a building project to see it is being done safely and to code, and a decreased individual right of privacy prior to any occupancy. Inspection rights can be incorporated by specific language in the permit as a condition of the issuance and the viability of a building permit, with the applicant consenting to such inspection by making and signing the application. Some key items in the Fifth Amendment review. The Fifth Amendment is where you find the takings clause. Case law includes Dolan versus City of Tigard. The Fifth Amendment's language, nor shall private property be taken for public use without just compensation, as well as the Due Process Clause of the 14th Amendment. In Dolan versus the City of Tigard, Dolan owned a commercial property which had been declared a non-conforming use. Dolan wanted to extend that non-conforming use. Dolan also owned on that same property access to a waterway. The City of Tigard approached Dolan and said they would allow him to extend the non-conforming use if he would grant the city a portion of that waterway property for the city and the enjoyment of all the occupants of the city. Dolan sued. The result was that when a government authority attaches a condition to a building permit, the burden on the property owner must be roughly proportionate to the benefits for the government. The city's dedication requirements constituted an uncompensated taking of property, a Fifth Amendment violation. The court held that under the doctrine of unconstitutional conditions, a government agency may not require a person to surrender constitutional rights in exchange for discretionary benefits, where the property sought has little or no relationship to the benefit being conferred. Following up on Dolan versus City of Tigard, several years ago, the Supreme Court developed a test which can help a municipality determine whether or not its easement requirements constitute a takings under the Fifth Amendment. In Dolan versus the City of Tigard, the court outlined the rough proportionality test. Under this test, no precise mathematical calculation is required to determine what constitutes a taking. Rather, the city or municipality must make some sort of individualized determination that the land required to be dedicated to public or governmental use, as set out in the ordinance, is related both in nature and extent to the impact of the proposed development. Although this test is more exact than others that have come before it, applying it to particular facts has apparently caused its share of confusion. As of 1975, the court has refused to refine or elaborate on the test. In a case that involved both estoppel and vested rights, Doles Enterprises in the city of Troy, Illinois, was a developer who bought land based upon an assurance from the city that the property was zoned R2. Their intention was to build multifamily housing complexes. The city issued building permits for the multifamily housing complex. The city soon determined that the land was actually zoned R3. The city revoked the permit and issued a stop work order. At the time, the project was 70% complete. The developer sued. The court held in favor of the developer on the case. After applying the requirements set forth in law and the facts of the case, the court determined that the plaintiff expressly conditioned its purchase of the land upon it being zoned for multifamily housing dwellings, and it was more than reasonable to assume that the plaintiff would rely upon the representations of the city clerk and the building inspector when it began to build upon the land. In fact, the court concluded that the city induced the plaintiff to purchase the land. It held that an injunction was necessary to avoid the irreparable injury that would befall the plaintiff if the city was allowed to enforce a stop work order. Recent court actions have found that a permit issued in error may still be revoked, but the cost of the mistake should fall upon the entity who negligently issued the permit. Keynotes concerning the 10th Amendment of the U.S. Constitution. The powers not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states, respectively, and to the people. This is where we find the police powers in the 10th Amendment. Key concepts of the 14th Amendment. This is the Equal Protection Clause. No state shall deny to any person within its jurisdiction the equal protection of the laws. The Equal Protection Clause applies to building codes in two ways. Number one, the code applies to people and buildings that are similarly situated in substantially similar ways. Number two, prohibits discriminatory enforcement of the code. Two concepts, facial validity and discriminatory enforcement. The Equal Protection Clause prohibits discriminatory enforcement of the code. Discriminatory enforcement does not look at the facial validity of the law, but rather on how the law is applied. When an individual who is found in violation of a building code raises the defense of discriminatory enforcement, he or she is claiming they are being singled out for enforcement. In the classic case of Wu versus Hopkins, a San Francisco ordinance barred the operation of hand laundries in wooden buildings, except by consent of the Board of Supervisors. In practice, the board denied all applicants of Chinese origin while granting permits to all but one of the non-Chinese applicants. The court held that although the ordinance has facial validity, it was administered in a discriminatory manner. The builder or developer challenging a provision of a local building code bears a heavy burden. First of all, the courts will ordinarily presume that the law is constitutional. That is, without compelling proof to the contrary, the court will uphold the legislative enactment. In an example, we have Eggert versus Board of Appeals of the City of Chicago. An owner of an existing wood frame structure challenged the constitutionality of a law which prohibited any more than 4 dwelling units in a building of wood frame construction. The court upheld the law. The court understood from the record that the purpose of the legislation was to protect against fires and to minimize the danger that would be done if one were to start. This purpose was legitimate, and the court felt the means to reach it were reasonable. Until the early 1960s, federal, state, and local governments were almost completely unaffected by civil rights legislation. In 1961 and the years following, the Supreme Court began to interpret heretofore untapped legislation that provided cause of action for people who suffered civil rights violations at the hands of the government. Section 1983 is a cause of action under which a state or local government can be held liable for money damages and declaratory relief for violating the Constitution or laws of the United States while acting under the color of state law. Some commentators have declared that no statute is more important in contemporary America than Section 1983. Nevertheless, before 1961, the Civil Rights Act of 1871 was rarely invoked. Within the last 30 years, this statute has become the basis for almost all constitutional rulings arising from the actions of state and local government. Section 1988, the Attorney's Fee Award Act, is one of the most important innovations in civil rights litigation. This act allows the plaintiff to recover any expenses incurred for attorney fees in the prosecution of the case. Therefore, if a defendant loses a Section 1983 lawsuit, the defendant may face payment not only of the actual compensatory damages awarded to the plaintiff, but of the attorney fees as well. In 1990, Congress continued its intervention in both the private and public sectors on behalf of disabled persons with its adoption of the wide-ranging Americans with Disabilities Act. This act covers employment discrimination, public transportation, public accommodations, and telecommunications. The latest edition of ICC's ANSI A117.1, Accessible and Usable Buildings and Facilities, may be the only accessibility laws in effect in many jurisdictions. This does not negate the responsibility for compliance by the owner of the Americans with Disabilities Act. Additional accessibility laws that must be considered and their enforcement entities will include the Americans with Disabilities Act, published and enforced by the U.S. Department of Justice, and the Fair Housing Act, amendments in 1988, published and enforced by the U.S. Department of Housing and Urban Development. The Equal Employment Opportunities Commission issued 2 regulations to enforce the provisions of Title I of the Americans with Disabilities Act on June 26, 1991. The provisions took effect on July 26, 1992, and covered employers with 25 or more employees. That was reduced to 15 employees on July 26, 1994. Before we begin our review of the Equal Employment Opportunity Act, we want to note that the application and interpretation of relevant federal statutes changes from time to time based in part on case law. Building officials should always consult qualified counsel in applying EEOC or any other legal standards in personnel administration. The Pregnancy Discrimination Act is an amendment to Title VII of the Civil Rights Act of 1964. Discrimination on the basis of pregnancy, childbirth, or related medical conditions constitutes unlawful sex discrimination under Title VII. Key components of the Act include the following. Employers must hold open a job for a pregnancy-related absence the same length of time jobs are held open for employees on sick or disability leave. They cannot discriminate, and they must make reasonable accommodations. Sexual harassment is a form of sex discrimination that violates Title VII of the Civil Rights Act of 1964. Unwelcome sexual advances, requests for sexual favors, and other verbal or physical contact of a sexual nature constitute sexual harassment when submission to or rejection of this conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment. Title I of the Americans with Disabilities Act of 1990, which took effect July 26, 1992, prohibits private employers, state and local governments, employment agencies, and labor unions from discriminating against qualified individuals with disabilities in job application procedures, hiring, firing, advancement, compensation, job training, and other terms, conditions, and privileges of employment. Title VII of the Civil Rights Act of 1964 protects individuals against employment discrimination on the basis of national origin as well as race, color, religion, and sex. A rule requiring employees to speak only English at all times on the job may violate Title VII unless an employer shows it is necessary for conducting business. The Immigration Reform and Control Act of 1986 requires employers to prove employees hired after November 6, 1986 are legally authorized to work in the United States. The Fair Housing Act of 1968. In recent years, there has been much attention paid to the millions of American citizens with some sort of physical or mental disability. In 1988, Congress amended the Fair Housing Act of 1968 to extend its protection to handicapped persons. A handicap was defined as a physical or mental impairment which substantially limits one or more of the person's major life activities. The goal of the amendment is to overcome the stereotype that people with disabilities cannot function in normal surroundings and therefore need to live elsewhere. This act is of importance to the building code official because it mandates design standards for new housing with 4 or more units. These standards are meant to ensure general access both around common areas and within the units themselves. Some of the many requirements designers and builders of structures of more than 4 units must follow are: number 1, doors, halls, and thresholds must accommodate wheelchairs. 2, light switches, electrical outlets, thermostats, and other environmental controls must also be accessible to people in wheelchairs. And 3, usable kitchens and bathrooms must be built so that wheelchairs can move about in the space. Let's review some definitions. Abusive process. A person who is found liable for abusive process is someone who has used the legal process as a threat to get something unrelated to the litigation. Absolute immunity, a policy of protecting public officials from tort liability. Assault, the willful attempt or threat to impose injury upon another. Battery, an intentional infliction of harmful or offensive bodily contact. Caveat emptor, let the buyer beware. Caveat venditor, let the seller beware. Centauri, a writ of common law issued by a Supreme Court. Contributory negligence, doctrine that holds that the plaintiff has been guilty of any negligence which has contributed to his injuries or damage, then he is totally barred from any recovery. De novo, a hearing that is reheld in front of the court. To continue, immunity, a legal privilege that prevents liability from attaching to the actions of certain individuals. It may be absolute or qualified. Liability, an obligation that one is bound in law or justice to perform. Lis pendens, legal proceedings which may be pending in court affecting the title or ownership of property. Owner persona, a person who is the owner of any fixed property or fixtures. Per se means in itself. Respondent superior, a doctrine that states that the master or employer is liable for the wrongful acts of his servant or employee. Ultra vires literally means beyond the powers. Voir dire, literally to speak the truth, typically in qualifying jurors. Remember to subscribe, like, and support these efforts that we're having for you, and we wish you the very best of luck in your professional development.